All right, let's dive right into this explainer because we've got a truly incredible story today. We're looking at the law, unintended consequences, and what actually happens when the very people writing and defending our statutes just completely drop the ball. We're going to examine a really fascinating case from the Constitutional Court of South Africa, case CCT 5705, for the legal nerds out there. It's a total masterclass in how a tiny, seemingly insignificant drafting error can spiral into a massive legal headache.
So, back in 2003, the Gauteng Liquor Act was trying to regulate the retail sale and supply of liquor in the province. And a huge part of that was figuring out exactly how to classify and regulate a shebeen. The law defined it by stating it's an unlicensed operation, mainly doing business in liquor and selling less than 10 cases of beer. Sounds specific enough, right? I mean, it literally specifies the exact volume of the bottles, 12 times 750 milliliters.
But there's a glaring oversight here that actually makes this law completely unenforceable. See, when lawmakers write statutes, they absolutely must provide what courts call reasonable certainty. Basically, citizens need to know what the law actually requires of them so they can, follow it. Despite the incredible specificity about the exact size of the beer bottles, the drafters of the Gauteng Liquor Act forgot one vital ingredient. Have you spotted it yet? Keep that question in your head as we step back for a second to look at the bigger picture.
Section 1. Normalizing the shebeen. Context is everything.
To really understand the splendor, we have to look at the history. We aren't just talking about abstract legal theory here, we're talking about a law that directly impacted the livelihoods of thousands of people. For a really long time, shebeens were forced to operate in the shadows. They were small traders operating out of private homes and townships, and their businesses were always considered unlawful, which obviously left them incredibly vulnerable. So the 2003 Gauteng Liquor Act was actually trying to do a good thing. It wanted to normalize the sale of liquor by shebeens for the very first time. The whole plan was to give these traders a window of time, a phase-in period, to get temporary permits and eventually comply with the super strict requirements of the formal Liquor Act.
Section 2. The missing words, a constitutional flaw. Okay, so here is the fatal flaw. The law restricted sales to 10 cases of beer, right? But it completely forgot to specify a time frame. Think about that for a second. You've got a marginalized group of business owners eager to finally operate legally, and a government trying to regulate a substance they consider harmful. But if you sell less than 10 cases of beer per day, are you a shebeen? What about 10 cases per year? The law was just entirely silent. That made it impossible to know who actually qualified for this new legal protection. No one. Not the liquor board, not the police, and definitely not the shebeen owners themselves could figure out exactly who fell under the protections of this new phase-in period.
Because of this totally missing time frame, the Constitutional Court had to step in and declare the definition impermissibly vague, which basically means it violated the foundational rule of law. Justice O'Regan wrote the unanimous judgment, and she pointed out that the rule of law is a founding value of the South African constitutional democracy. It demands that laws be written in a clear and accessible manner. You don't necessarily need perfect lucidity, but you absolutely need reasonable certainty. And because this definition had literally no time frame, its meaning just couldn't be figured out with any precision. It was fundamentally broken.
Section 3. Fixing a broken law. Severance versus reading in.
So what do? How do you fix a broken law without accidentally rewriting it entirely? Because courts aren't supposed to be lawmakers. Their job is to interpret the law and strike it down if it violates the Constitution. But completely striking down a law can sometimes cause even more chaos. Now, the Pretoria High Court initially tried to fix the problem through something called severance, which is basically just chopping off the second half of the sentence. They made it so a shebeen was simply any unlicensed operation whose main business is liquor. While the Constitutional Court looked at that and realized, hold on, if you do that, any massive, completely unregulated liquor retailer could just claim to be a shebeen and bypass all the strict regulations of the Liquor Act. That totally undermines the government's entire purpose of regulating a harmful substance. So instead, the Constitutional Court favored reading in, which means actually adding the missing words back into the statute to preserve what the legislature originally intended.
Section 4. The 60-case compromise. Data-driven justice. The Constitutional Court decided to read in the missing words, but they needed hard data. They couldn't just guess what was happening on the ground in the townships. Should they read in per day, or maybe per week? Well, before the court case even happened, government officials had just arbitrarily decided to print per week on the physical permits, capping sales at 10 cases. And to make matters worse, the permits explicitly restricted traders to only selling beer, basically threatening their very livelihoods. The shebeen owners took this straight to court,
basically saying, guys, running a profitable business on just 10 cases of beer a week is financially impossible.
So the applicants in this case submitted actual evidence to the court. They provided affidavits from 30 different shebeen owners who would apply for permits. And the data showed that, on average, these small traders were actually selling just over 60 cases a week. And amazingly, the government produced absolutely zero evidence to contradict this data. Nothing. So based on these affidavits showing real-world average sales, the court adjusted this limit to a much more realistic 60 cases.
As an interim remedy, the court crafted this super practical, evidence-based compromise. It was designed to keep the industry running legally while giving lawmakers 6 months to write a proper law. The court didn't want to leave the industry in unregulated chaos, but they also didn't want to enforce a 10-case limit that would literally bankrupt the traders. So they read in the words per week, raised the limit to 60 cases, and explicitly ruled that shebeens could not be restricted to selling only beer. It was a temporary fix. The court essentially told the Gauteng legislature, all right, you have 6 months to go back to the drawing board, maybe hold some actual hearings, and write a law that makes sense.
Section 5. A costly legal blunder, the sting in the tail.
While the constitutional mechanics of all this are fascinating, what happened behind the scenes with the state's legal representation is just truly mind-boggling. The state attorney representing the government showed a baffling level of negligence. Ignoring court orders and missing critical deadlines one after another. Check this out. The Chief Justice of the Constitutional Court issues directions on January 24th asking the government to explain itself. The deadline passes. Nothing. The deadline for written arguments passes. Nothing. Finally, on the day of the actual hearing, March 2nd, the state attorney doesn't even bother to show up to the highest court in the land. The court literally had to have an official from the registrar's office call the attorney on the phone and ask them to come down.
When the court demanded an explanation for this, the excuse provided was absolutely staggering. A junior attorney simply filed the Constitutional Court's directions without even reading them. It revealed a massive lack of supervision. The state attorney's office basically threw a recently qualified, totally inexperienced junior attorney right under the bus. She submitted an affidavit saying she received the directions from the Constitutional Court, assumed they were just some random update, and put them in a file without reading a single word. And no senior attorney provided an affidavit explaining their systems for supervision. The highest court in the country was quite literally treated like junk mail.
To enforce professional accountability, the court hit the state attorney's office with a very rare and severe penalty, paying the wasted court costs out of their own pockets. In the legal world, this is called a de bonis proprius cost order on an attorney and client scale. It is incredibly rare. The court only does this when there is negligence of a very serious degree. It's a massive judicial red flag designed to say, look, your conduct is so entirely unacceptable that the taxpayers aren't going to foot the bill for your mistakes today. You are.
The judgment delivered a total judicial smackdown, calling out the woefully inadequate training and the lamentable want of professional responsibility. Justice O'Regan made it crystal clear that attorneys are officers of the court. The government, as an organ of state, has a strict constitutional duty to assist and protect those courts. By ignoring the Constitutional Court, the state attorney's office gave the distinct impression that the provincial government just simply didn't care about the constitutional rights of the citizens or the authority of the judiciary.
And that leaves us with a pretty provocative thought to end this explainer on. A legal system is really only as strong as the competence and the accountability of the people running it. We started with just a few missing words in a single sentence that somehow threw an entire industry into chaos. But we ended with a stark reminder that even the most perfectly drafted laws mean absolutely nothing if the lawyers and officials responsible for upholding them are fast asleep at the wheel. When the defenders of the rule of law can't even be bothered to read their mail from the highest court in the land, how secure are the rights of the everyday citizen?